So our next presenter is Mrs. Cleopatra Christie, and I'll give you a little bit more information on her. Mrs. Cleopatra Christie, born in New Providence, received her early education in the UK. She joined the Office of the Attorney General in 1973. Over the years, she rose through the ranks to the post of Assistant Director of Legal Affairs. Magistrate for the first drug court in the Bahamas in the 1980s. She was also the former magistrate for the family and domestic courts. In the year 2000, she went into early retirement from the Office of the Attorney General, joining Scotiabank as their legal and compliance manager from 2000 to 2009. In 2012, she returned to the Office of the Attorney General as a consultant on the criminal side. Mrs. Christie is presently the administrator at the Bahamas Crisis Center. So now, coming to present on the Domestic Violence Protection Order Act, Mrs. Cleopatra Christie.
Okay, thank you for that. The Domestic Violence Protection Order Act was passed in 2007. Now, we're talking about domestic violence, and we're wondering, well, what can the court do to assist victims of domestic violence? Well, this is one way. We were privy this morning to the conversation with the Commissioner of Police, and he told us about all of the policies that he has implemented. But the Protection Order Act is an intervention by the court, and it is set up to provide help and protect victims, whether they are women and children, from the abuser. Now, when we talk about the Protection Orders Act, the first thing we ask is, well, what is a protection order? What does it do? How do we get a protection order? So a protection order is a document issued by the court, and it is signed off by the judge. And this document is the document that protects the complainant from harassment or from abuse. Now, how do you get it? Well, what happens is you have to prepare an affidavit, or you write your story. In these pandemic times when the courts are only meeting for emergency orders, what you do is you write out your story, you write the details of what has happened to you, how many times, what injuries you've received, when you went to the hospital, where did you go? If you made a report to the police, you write a whole complete detailed story, and you appear before the magistrate. And you swear that the contents of the document are true and correct. Based on the information you provide in that story, in the document that you provide to the magistrate, the court grants an interim order. So what does that interim order does? What it does, it just makes sure to stabilize the situation until you get back before the court, because the court will issue the interim order and then it will set a day for a substantial hearing. That is when the respondent, the person, the abuser, is served with a summons, and he is told to report to the court on the blank day of blank. So you go to court on a particular day before the magistrate, both parties, and the magistrate hears from both parties. And after hearing the evidence on oath, the magistrate makes a protection order if the evidence discloses that the complainant is in immediate danger. So these orders, when you appear before the magistrate, they are heard in camera. So lots of people don't want to go to court because they figure that it's a public forum and that everybody is going to hear about their bedroom business and the world is going to know about what happens in their house or behind those closed doors. So no, that doesn't happen in these civil hearings. And remember that a protection order is not a criminal offense, but it is a civil remedy. And so you appear before the court, and the only persons present in the court would be yourself, the complainant, the respondent, that is the abuser, the magistrate and her staff, along with the police. And so you have, you're able to speak freely. And of course, you don't have to fear the press. You don't have to fear the public eyes and ears. So you tell your story in the presence of the magistrate out of the hearing of the public. The magistrate allows you, explains the situation. She says what's going on. She explains the process. And if you wish to call a witness, that is, if the complainant wishes to call a witness, that is, if somebody has witnessed the abuse, or a police officer where you've complained, or a police station where you've been, or even a social worker where perhaps you've gone to the ministry and you've made a complaint about certain things there, witnesses can be called. And the same thing would apply for the abuser, the respondent. He too can call witnesses if they wish. So the situation is that after the magistrate hears the story from both parties, the magistrate, based on the evidence she's heard, he or she has heard, the protection order is made. Now, when a protection order is made, the court takes into account the story. The court orders the abuser to stop abusing you and your children. The court can make an order for him to leave the home and stay away from you and the children, or even your workplace. There may be phone calls. It may be somebody who's calling every minute, sending letters, sending emails, sending messages. The court could include that in the order and say, look, you cannot do this. You are prohibited from doing such and such a thing. There may also be a question of the custody of the children. There may be visitations. There may be child support. All of these issues can be heard and dealt with at this time. And when the court makes an order, the court can make the order to include the order either to pay child support, maybe there's custody, maybe there's visitation. That is, when the father of the children can see and visit with the children. Sometimes the court order can include for the abuser to pay expenses. Suppose in the process, one of his outbreaks, he breaks your glasses, he damages your car, he damages some other property. He might have taken the clothes and thrown them outside and wet them up or leave them outside in the rain or something like that. The court can order that the respondent, the abuser, pay and compensate you for the damage that he has caused. And the court can also order counseling. Now, the court would have had a preview of the relationship, what has happened. The court may be of the view that maybe with counseling, you can rectify, restore the relationship. Well, we don't know that, but the court has a right and could order counseling. So when the court has completed the order is placed in a form. It is typed out by the office and it is placed in a form. and it is signed off by the magistrate, and that order is served on the abuser who is in court. The order should be served on the police station in your area where the abuser, where the complainant lives, so that if anything happens and she returns to the police station would have that order on file. And it gives the police the power to act. The police can go in and arrest, make an arrest, and take him into custody. The police can go, depending on the circumstances and the facts, the police can go in and speak and to make sure and stabilize the situation if that is what has happened. But if that abuser is in breach of the order, the police would have the power to arrest. So you see, the court has the power, a wide range of things that the court can do when one approaches the court for help and intervention in a domestic dispute. So the police plays a very important role in this intervention. We heard about, the complainant makes a report to a police station. The police keeps those reports on file. You can refer those reports to the magistrate when there is a hearing. The police must be informed and must have on file a copy of the report, the order, and so that they can act if there is a breach of the order. And you know, sometimes when parties appear before the court, one of the complainants make is that, oh, my husband has a gun. And that's very important because a gun is a lethal weapon and it's a frightening weapon to have in the home, and especially if the home is unsettled. And so the court can make an order in respect to that firearm to be removed from the home if the evidence so produces and discloses. The court can do that. And of course, if you get the police involved, the police can go to the house and remove that weapon from the house until the situation is settled or until the court makes an order as to what is to happen with the weapon. Now, just a quick word on the act. All of the things that I've just been speaking to you are all contained in this Domestic Violence Protection Order Act, number 24 of 2007. And so what I've done is I've really just lifted parts of it and condensed it. We don't have the time to go through it all. But when we look at this piece of legislation, one thing it does, it defines domestic violence. And so before I close out, I just wanted to give you a brief overview of what domestic violence is so that you would understand where the infraction occurs. So domestic violence includes the physical, the sexual, emotional, psychological, or financial abuse committed by a person against a spouse, partner, child, or any other person, a member of the household. So it has a wide range of the definition is wide, and it includes all of those things. And the act goes on to define what emotional and psychological abuse is. It even defines financial abuse. And you know, financial abuse is important. It means a pattern of behavior, the purpose of which is to exercise coercive control over or exploit or limit a person's access to financial resources as to ensure financial independence. So it means, well, I'm going to give you no rent. You don't have no grocery money. I'm not going to pay the mortgage. I'm not going to pay the car note on, and all of that sort of stuff. So if any of those things are happening to you, you can approach the court and ask the court to intervene, and on the basis that you are suffering financial abuse, and the court hears both sides, and we go through the process as I've just outlined. Another aspect of this, which is important and happens very often, the act defines harassment. And we talk about this word harassment and we throw it around very casually, but it has a legal definition. And it means persons who persistent verbal abuse, threats of physical violence, if they damage your property, unwanted physical or visual sexual advances. You have some people who behave like that. They may use their eyes, their hands, or even their tongue sometimes. Also, this harassment includes emails, telephone calls, drawings. Somebody might do a drawing and then put it up on a billboard so other people can see. Also, stalking, hiding people's clothes. All of these things, sort of a pattern of behavior that falls within domestic violence, and you can approach the court and ask the court to intervene so that you're protected from whatever behavior that is being exhibited. So the Crisis Center have a number of lawyers attached, and we from time to time have to appear before the court on behalf of some of our clients. And depending again on the facts they exhibit, they tell us and disclose to us, we're able to follow the process that I outlined to you. That is, we are able to get their story in writing, they appear before the court, and in most cases, we're successful in having the court issue a protection order in those cases. And so I would stop there and see if there are any concerns or questions about the Protection Order Act or anything associated with the process.